California has some of the most tenant-protective eviction laws in the country. If you're a California landlord, understanding this process before you need it is essential. Step 1. Determine the correct notice. For non-payment of rent, California requires a 3-day notice to pay or quit. For lease violations, a 3-day notice to cure or quit. For no-fault evictions on properties covered by AB 1482, California's statewide rent control law, you typically need a 60-day notice with a just cause reason and, in many cases, 1 month's rent in relocation assistance. AB 1482 applies to most rental properties in California that are more than 15 years old and not single-family homes with a specified exemption notice. If your property is covered, you cannot evict a tenant without just cause after 12 months of tenancy. Step 2. Serve the notice properly. In California, proper service means personal service, substituted service at the residence with mailed copy, or posting on the door with mailed copy. Improper service is the most common reason unlawful detainer cases get dismissed. Step 3. If the tenant doesn't comply, file an unlawful detainer in the Superior Court for the county where the property is located. California filing fees currently run approximately $240 to $435, depending on the amount claimed. Step 4. The tenant has 5 business days to respond after being served the summons. If they don't respond, you can request a default judgment. If they do respond, the case is set for trial, often 7 to 20 days out. Step 5. After judgment, the court issues a writ of possession. The levying officer, typically the sheriff, posts a 5-day notice to vacate and then physically removes the tenant if necessary. Total realistic timeline: 4 to 8 weeks for an uncontested case. Contested cases can take 3 to 6 months or more in high-volume counties like Los Angeles. TenantScreeningBackgroundCheck.com. Thorough screening before placement is always faster than eviction after it.